Chapter 3 on Equitable Waste 36 and 37 Vict. c. 66, Sect. 25, Subsect. 3. An estate for life without impeachment of waste shall not confer, or be deemed to have conferred, upon the tenant for life any legal right to commit waste of the description known as equitable waste, unless an intention to confer such right shall expressly appear by the instrument creating such estate. A. An estate for life. It does not appear why estates for years are not within the sub-section. Such cases, however, and all other estates not expressly within it, are, if dispunishable at law but not in equity, practically brought within it by subsect. 11. For there is then a conflict or variance between the rules of equity and the common law. Thus, an heir claiming under a resulting trust until the happening of a contingency, who is dispunishable at law, but has been restrained in equity from even legal waste, is within subsect. 11. And so of a devisee in fee, with a legal and, a fortiori, an equitable executory devise over on his decease without leaving issue, who was dispunishable at law for legal waste, unless he is by the will made impeachable for it, as he may be, but who might not commit equitable waste. It is not easy to understand, therefore, why subsect 3 was necessary at all, or why it should be framed on so narrow a basis as it is. B. Without impeachment of waste. I. By operation of law, as where term for years sans waste settles the term on a. For life, without more. A. Is dispunishable for waste, and therefore would seem within the subsection. So, of tenant entail apers possibilite of issue extinct, who is a tenant for life, and dispunishable at law. Tenant entail apers, and c. is where one is tenant entail special, and he from whose body the issue was to spring dies without any, or his issue become extinct. So, of tenant for lives renewable forever, without more, who even if dispunishable at law, might not, though expressly sans waste, commit equitable waste. 2. By express exemption. 1. Absolute, of which nothing more need here be said. 2. Modified. The modification amounting, according to its stringency, either to absolute impeachability, as where voluntary waste is accepted, or to such a power as a prudent owner in fee, anxious to preserve an estate for his children, would exercise, as where the exception is of spoil or destruction, or voluntary or permissive waste. In the last named case the same prohibition of voluntary waste, as in Garth v. Cotton, did not lead Sir J. Romilly to the same conclusion as Lord Hardwicke. C. Any legal right to commit waste at law, or legal waste, was a substantial injury done by a limited legal owner of land not dispunishable for waste, in rightful possession, to the inheritance thereof. Privity of estate, therefore, between him who commits, and him who complains of, the waste was essential, and distinguished waste from trespass. This distinction, though the modern tendency of decisions has been to relax it, has run through all the cases. And inasmuch as trees, which are not timber, are not part of the inheritance, there is no such thing as waste at law in them, except perhaps in fruit trees, or in trees for shelter or protection of banks, or in germines, i.e. young plants which if old enough would be timber. But, semble, equity will not allow him the property in them if wrongfully cut. Timber are trees useful for building. Ash, oak and elm, of 20 years, everywhere, and by local custom. Other trees, if not too old. In some places the age for timber is more than 20 years, and the test, not age at all, but girth. Timber estates are those cultivated merely for the produce of saleable timber, which is cut periodically. Felling of timber on such estates by a tenant impeachable is not waste. D. Of the description known as equitable waste. As the Act abolishes the legal power of a tenant for life sans waste to commit equitable waste, the old definition of that phrase, viz. the excessive use by him of his legal power, no longer seems to apply. Another definition of it, that it is such waste as a prudent owner would not commit in the management of his own property, has been objected to, at least in connection with ornamental timber, on the ground that every tenant sans waste is bound by the taste, or want of it, of any absolute owner planting it or leaving it standing for ornament. It may therefore, perhaps, be best defined as such waste, by a tenant sans waste, whether legal or equitable, the court interfering more readily in case of a trust for ornament, as is unconscientious in a court of equity. Unconscientious waste, in the eyes of a court of equity, is anything tending to the destruction, or wanton spoliation of the land. The wantonness is inferred from the character and extent of the act, and a malicious animus need not be proved. A court of equity would also restrain mere legal waste, either to support the legal right in urgent cases, or because legal process was from some technical impediment unavailable, and thus might be obliged to determine the legal question, what is, or is not, waste. Tests of equitable waste, by a tenant sans waste. 1. The court considers whether there are special circumstances affecting the conscience of the wrongdoer. 2. In such considerations the intent of the donor of the power to commit waste is chiefly regarded. 3. Trivial unconscientious waste is disregarded. 2. Acts of equitable waste by a tenant sans waste. 1. To strip or pull down a mansion. 2. To pull down a farmhouse. 3. To cut ordinary timber before it was his day, i.e., before possession, if the estate is thereby stripped. If cut in an unhusbandlike way, i.e., in an improper way, e.g., if too young, or overripe, or at unseasonable times of the year. If planted to protect or shelter mansion. If thereby a wood is grubbed up, to cut ornamental timber or ornamental trees, though not timber. I do not find that timber-like trees differ essentially from timber, provided they are planted for pure ornament, i.e., not for profit. Although planted by himself, distant, and separated from mansion by another's grounds. Ornamental only to gardens, park, rides or drives. If near a ride or drive, the whole wood will not be within the protection. Planted to exclude objects from view. The mansion, which they adorned, has been pulled down, if intended to be rebuilt. Unless he cuts, to cure, by producing uniformity, gaps by tempest. To thin them, to prevent their being injurious to the house, as by hindering the growth of other trees. For repairs, or sale, the settler having done so in due course of husbandry. 5. To cut underwood at unreasonable times. 6. To cut saplings maliciously, as, and for the purposes of, timber. That is trees not fit for, but which would become, timber. To dig brick, gravel, or stones, so as wantonly to destroy the inheritance. 8. To open and dig new mines, in a wanton and malicious way. Yet every mining operation is, pro tanto, a destruction of the property. 3. Tests of ornament. 1. The taste and intent of settler, irrespective of the character of the trees. This intent is less difficult to ascertain in trees planted, than in those left standing, for ornament. 2. He must have dedicated them to ornament. Such dedication presumed, if near a mansion. But a dedication of part is not a dedication of the whole of a wood. The measure of damages due for the cutting is the damage done to the inheritance. Interest in equitable waste. The subject of the interest in the property wasted, though not strictly within this subsection, is too closely connected with it to be passed over. In declaring the title to equitable waste, equity has been said to follow the doctrine of law as to legal waste. That doctrine is, that it casts the right to the waste on the owner of the first vested estate of inheritance in esse at the time of the waste done, who may accordingly seize the wasted property. Timber money is realty, if nothing is done by the owner of the inheritance to convert it into personalty. But equity secedes from this doctrine in the case of legal waste, and acting on the principle that no man shall obtain advantage by his own wrong, not only if the owner of the first existent estate of inheritance, subject to prior contingent estates of inheritance, b, or collude with, the wrongdoer, excludes the wrongdoer from the proceeds of the waste, either capital or income, but will order them to be invested on the same trusts as the land, so as to follow the uses of the settlement. And equity follows the same course if the waste be equitable, and will not prefer a vested to a contingent inheritance, unless the former be heir apparent, i.e., one who, if he lives long enough, must become entitled in possession. Equitable waste is a breach of trust, and the assets of the wrongdoer will be answerable for it. F. Interest, in equity, of tenant for life sans waste, in rightful fellings, and in windfalls. In waste by prior tenant. The law of waste to buildings is the same as of waste to trees. There seems no direct decision that a tenant sans waste is entitled, except during the privity of his estate, i.e. till he comes into possession, which he never may, while the property of the thing wasted must be in some one eo instanti the wrongful act is done, and that person is the owner of the inheritance. 2. A rightful felling is won by a court or by a trustee if adopted by the court, or by a tenant impeachable of a timber estate, and, of course, is not waste. The court will, on application by a tenant for life impeachable, order ordinary timber to be cut when it is decaying, on will not improve, or injures other timber, but not merely because it is ripe, and may direct the proceeds to be paid to trustees approved by it, or into the Bank of England or Ireland and applied. 1. In purchasing or redeeming land tax or encumbrances on the settled lands, or on lands subject to the same uses, or 2. In purchasing other lands to be similarly settled, or 3. In payment to person absolutely entitled. The court has power to cut ornamental timber, or trees not timber, e.g., where they make a house unhealthy from their proximity. This power, and, except where it has been extended by the Settled Estates Act, its power to cut ordinary timber, is under its ordinary jurisdiction. The capital of the proceeds of rightful fellings belongs absolutely to the first tenant for life sans waste, whether legal or equitable, if prior, in the limitations of the settlement, to the first estate of inheritance. Prior tenants, though impeachable, taking a life interest in such proceeds, except in timber estates, where the fellings, being regarded as annual profits, belong absolutely to the tenant impeachable. 3. In rightful fellings, by prior tenant impeachable, of trees not timber. The felling, or thinning, of trees which are not timber, by a tenant impeachable, is not, with the exceptions before mentioned, waste at law, and therefore the legal property in their proceeds is in him. And so of thinnings, by such a tenant, of trees, which, though not timber, would become timber, if done to preserve and improve timber trees. But trees, not timber, may be wrongfully cut by him, and semble. The rule of timber wrongfully cut would then apply. 4. In windfalls, i.e. trees severed by storm or tempest. These being the act of God, are no injury, and therefore no waste. 1. Windfalls of sound timber belong, as between tenant for life and remainderman, who stand in the same relation as lessee and lessor, to the remainderman, if entitled in fee, or entail, or if he is tenant for life sans waste. If the tenant is for life impeachable, they belong to the first vested estate of inheritance, with, perhaps, a life interest in the produce to the tenant for life, subject to the question, which Mr. Craig is inclined to answer in the negative, whether the produce should be invested and accumulated for an ulterior tenant for life, if any, sans waste. Windfalls of unsound timber belong to the tenant for life. Windfalls of trees not timber, whether sound or unsound, belong to the tenant for life, for as he may cut, he may pick up,